Navtika Singh. Navtika Singh, ma'am. Namaste.
Namaste, ma'am. Namaste.
Faculty coordinator of JSS Law College, ma'am. And we also have our senior professor, Professor Nagendra Murthy sir with us, who is the co-teacher for ADR.
Namaskar, sir.
The brain behind this program, ma'am, I can say in one word. Kalpesh sir, can we start, sir? Thank you, sir. Thank you for your green signal. A very good afternoon to one and all present here. At the outset, I heartily congratulate all of us present in hybrid mode for this 5th day of online. I mean to say it is hybrid session. And we have with us Dr. Nautika Singh Nautiyal, who is presently working as an assistant professor in School of Law, Forensic Justice and Policy Studies at National Forensic Science University, Delhi campus. Ma'am is having 12 years of teaching experience and research experience. Ma'am has completed her postdoctorate from MICHR, Italy, in human rights and artificial intelligence, which is a very burning subject now, and done her philosophy of doctorate in inter-country adoption laws from Uttaranchal University, Dehradun, and Masters of Law from Indian Law Institute, New Delhi, in criminal law and human rights. Madam has a vast experience in writing and research. Madam is a very remarkable speaker, and ma'am has delivered a key addresses on various contemporary laws. To quote few, law related to management, legal research, personality development, professional and communication skill, etc. Ma'am is having 25 years of service in this particular field, and she has 25 prestigious editorial board. She's a member to it and reviewer of different national and international journals. She has edited 3 books, which is published in renowned publishing house like Thomson Reuters, etc. She has published more than 50 articles and research papers, which has been a part of various books. Ma'am has presented 90 papers, both in national and international events. Ma'am is also having a full scholarship to her work in clinical legal education in 10th and 11th Worldwide Conference of Gage at Indonesia and South Africa. With this brief introduction, I wholeheartedly invite you on behalf of JSS Law College and Pro Bono India, ma'am.
Thank you so much, ma'am, for your generous words. I am indeed touched with the way you have introduced me. Thank you so very much. I also wish to give my regards to Sir. Sir, thank you so much for planning this particular, event. As ma'am has rightly mentioned that you are brain behind it. So thank you so much for formalizing this. I also wish to thank Pro Bono India, especially Kalpesh sir, for having me here on this Saturday, afternoon. I have requested sir to prepone my lecture, and sir has very generously accepted this. Apologies for inconvenience, and thank you for understanding. The topic which sir has, given is indeed a topic of today's understanding, because when we see that what is access to justice and what is technology, we all have to see that we are living in technology, and because of the technology we all can sit at our respective place and can attend this hybrid event. This is all possible because of technology. So can we use technology in access to justice? This is the idea of this particular program. And with the permission of both the institution, if I may share my presentation, I can start.
Yes, ma'am. Please, ma'am. Permission granted from our side. Thank you so much.
Thank you, madam. Is my presentation visible to everybody?
Yes, ma'am.
Okay. So, good afternoon once again, all the dearest participants who have, joined at this afternoon. I'll assure you all that you will take something home today. Friends, the topic which has been assigned to me is role of technology in access to justice. Why we need access to justice? It is a fundamental right. Some of you will say that, madam, it is one of the fundamental right enshrined by Constitution of India. And it is our right. When I say that it is our right, it has some, duties reflected upon other people whom have a responsibility to implement to give, to adjudicate this particular right to all of us. It is one of the cornerstone of rule of law. The motto of ministry says "Nyay sabke liye." I don't know how many of you can read it in Hindi, but I wish to say that it means that access to justice for all. That means all means we all are part of this. We, the people of India, as per the Constitution, everybody has the surety and the opportunity to seek and obtain legal remedies and grievances. uh, we are living in a society, it is not law and lawless society, it is a lawful society where rights and duties are balanced in our society. Friends, when I'm saying rights and duties are balanced in my society, I mean to say that remedies for grievances are there. When I'm saying remedies for grievances are there, we have constitution in our hand who is establishing that you all can access to justice. Justice does not mean law. Justice means what is just, right, and reasonable. So, friends, the accessibility to it. Not I'm talking about Article 12 and 14 right now. I'm talking about an article which says that you all can be just, fair, reasonably accepted in the country like India equally. But don't you think that there will be challenges? Challenges like the legal cost. You go to an advocate who has 10 years, 15 years, 30-year practice. The advocate will ask handsomely, it may be out of our pocket. Question number one. Question number two, we see that justice delayed, justice denied, justice hurried, justice buried. How to make a balance? Delays are there in society. We can't go with the delays. However, as per new criminal laws, it said that we have timeline fixed for everything. But can after fixing a timeline is the assurance that justice will be given? It is given us a thought that can we avoid delays? We have another theory which says that justice hurried, justice, buried. So justice shall not be given in hurry. Justice has to be followed due process of law. The third one comes is lack of awareness. On the lack of awareness part, we all are sitting here where this particular 10 days program has also been organized to aware us all. We are from legal fraternity, but we also need to have the awareness that what is new coming, how we can use particular subject, how we can use particular mechanism. For example, online dispute resolution. Nowadays, we all are talking about ADR, we all are talking about mediation, we all are talking about negotiation, but are we all aware that how we can use them in real sense? That is a question, and this question is very significant and pertinent. So, lack of awareness is there. Imagine we all are from legal fraternity. Uh, on In March itself, I have attended a seminar on mediation and arbitration. There, I have, I got the opportunity to hear from one of the person from ministry who's dealing with arbitration, mediation, and negotiation. He said that there are people who are not aware. The moment court is saying, refer this matter to arbitration, they have this dilemma in mind that now the case has gone. Arbitration will not decide anything, and arbitral award is good for nothing. That is misunderstanding. That is the kind of situation where everybody has to see that it is new normal. It is which what we have to accept. The lack of awareness is another biggest challenge, my friends, which we all have to understand. Now, question comes, ma'am, what is the solution? Solution, one fold solution I am here to tell, and this session is, for that. That is, can technology help us all in, systemizing the complete legal fraternity where we can use the technology for access to justice. Now take a 2 second pause, think, where every other person is telling that technology is bringing this poor thing, technology is bringing that bad thing. Here is one person sitting, in front of your screen and saying that you can use technology for access to justice. And I want to assure you all, after this 1 hour lecture, you all will understand that technology can be used for access to justice. But again, there is everything has a limit. If we will know that how much to use and how to optimally use, then न्याय सबके लिए access to justice for all will be achieved. With this background, with this prologue, my friends, let me take you to an understanding to a world where technology is helping us all for justice. But you will have questions. Kindly reserve your questions or write in the chat box for me so that I will be able to help your question and make you understand that how we can use technology for betterment of our society. So the second thing which is in my presentation is technology and legal service. Why? This question must have come to you all that, uh, ma'am, we don't want. We have district legal service authorities, we have state legal service authorities, we have national legal service authorities, we have pro bono India, we have legal assistance centers in all law colleges, schools. We have we have other mechanisms also. I'll discuss them also. Why we need then technology in legal services? My friends, I am not denying that all the stakeholders are there who are there. They're not working, they're working handsomely, marvelously, and they're doing the best what they can do in their capacity. I am here talking about let's uplift their capacity so that the legal service can be provided to everybody. For instance, let's have a system where you can launch your complaint and a person can be available to you, which has been given by Department of Justice. I'll discuss with that tele law services also. So my understanding to you all is technology is more efficient. Technology will not be tired, will not see that it is working 24 hours, 365 days a year. It will not see that, okay, my 10 to 6 is done, now I am closing my office. No, you can email, you can access from anywhere. It is more time and energy consuming. You need not to go to the office of DLSA for every small thing. You can access, for example, now we have just is the application where the cause list, your status, orders, everything is available. Now you need not to go to court for every other certified copy of your order. Is it not cost effective? It is not time saving. It is. Then the accuracy is optimum. You will have the more accurate data understanding of the technology. Then also there is further much thing, that is reach to maximum people. This seminar, if it would not be online, it would be very difficult for me and for everybody to go to Mysore and attend it. Technology has made it reach to maximum people, and then it can be recorded and provided further to multiple people. That is the beauty of online services. That is the beauty of the technology. But it is not done with the situations, with the complications. I am going to discuss challenges also with you all. Then how can we use the technology for access to justice? kindly do not, annotate on my presentation. I request the admin to please not give control for annotation on my presentation. Uh, can we use technology in access to justice? If yes, how? If no, then why not? I wish to have here 3 seconds pause and to understand, can we use technology in access to justice? My response is yes. Then you'll ask me how. My answer would be, there are applications, there are portals, there are chatbots, there are websites, there are emails, there are telephonic awareness, there are other situations which are there who can give access to justice, and we can use it. You say that, ma'am, we don't want it. Why not? If you will not be pace up with every other country, for everything we looked up to west, for this west shall look up to us, that why India is doing. Let me tell you here an example. I'm working on one of the thing, it is yet in developing states, so I cannot discuss more with it. I discussed with one of my friend in South Africa. She told me that they don't have that system. Their orders, their cause list is not available online. And it was to my amazement. I was like, but in India, we are doing that. That is very much, here. She's like, we're trying even that e-code system, e-filing system is yet not been developed by them. That means we can help them. Yes. So, friends, it's like, we need not to learn everything from others. Even others can learn from us. At least the, neighboring countries, we can make a system and give it to them. That will improve the legal aid access. That will enhance or increase the case management. Uh, right now, we can get the data how many cases are pending and how many cases are what stage. That is the beauty. That means we are in safe hands. Also, it will ensure the transparency and accountability, which is deeply, not rooted in Indian, system. We have had so many instances of corruption, so many instances of, unaccountability. The role of technology in justice delivery mechanism will ensure transparency and accountability. Recently, there was this arbitral award which has been set aside. You all must be following that news. If it would be there, it would have not been set aside. So use technology, but does not overuse technology. The next thing, which is, I have an exercise, and I request all of you to please use chat box for this. My question to you all is, which technology can be used for access to justice? Can you name few? If you can chat, if that option is available with you all, please write in the chat box that which are the different technologies can be used for access to justice. This is the exercise number 1. Otherwise, also I'll give this exercise to the organizers. They will ask this questions to you all. Let me further move. There are three platforms. The first one is electronic filing. Friends, this was a biggest task, that take the printout, go to the filing center, do it. Now we are having electronic filing. It is not everywhere. Okay, I would be accepting your response when you say that madam, it is yet not it at our place. It may be possible, but in most of the places, the electronic court filing processes has started, and it is saving time, energy, papers, cost, everything. Plus, it will not have that question that papers are missing, file has been lost, file has been burned, evidences has been gone. This will stop all those things. So the first one is standardized court filing process, immediate access from any location. You need not to get everything with you. You need to just carry the number given to you, and you can easily access from any other location. That is first, first important thing. The second one is there are public access kiosks. This is the second thing which is being established, that there are ideal in areas of low population density. There are, villages, there are urban semi villages, or semi urban areas where the population is lesser, than density is lesser. The public access kiosk being put up at courts, community centers, libraries, and even supermarkets, where you can access the information. If you all have been to libraries, there are kiosks in the library where you put the number, you can see that whether this book is being issued by X person, Y person, Z person. The same kind of public access kiosk I'm talking about. You can fill your number, certain details which are personal to you, because everybody shall not access that, and you can then see the status of your case. Your advocate may not be able to lie to you if the advocate appeared or not, if the case has been given. I'll tell you one very, like, there may be thousands of this kind of example. Let me share one example where Mr. Advocate did not went to the court. The court has given an ex parte order, and Mr. Counsel has told the parties that we have had ex parte order is in your favor, but I did not like the order. I'll go to higher court in appeal. Now the problem is that the client was not so much literate. They came to our legal aid center. They said, Madam, what is ex parte order? I was like, when one party did not went to the court will give ex parte order. They were like, Madam, this is in our favor, and our advocate has said that this is good. It is in our favor. I was like, no, ex parte order. Uh, is something which is completely wrong. Your advocate must not have went to the court on time, or maybe have missed dates. Then they realize that whatever Mr. Advocate was telling. Now the question comes, you may ask, ma'am, if they are not so much literate, why didn't they Google it? The problem is Google provide not all the right informations. It also does not have its brain. So public access kiosk may give you right kind of information, but again, awareness is required. Then the third one is, when you must have mentioned that why didn't they ask Google? Internet self-help sites help them for access to justice. The first one is free access to legal information. Like every other legal information is available. Like Manu Patra provides so many legal informations. PRS provides all the Bayer Acts, all the all the relevant legal documents. Law Commission's website provides all the legal documents. All the proposed bills are on PRS. But other than this, there are so many self-help sites. For example, even Pro Bono India provides so many legal informations for people on their Insta, on their Facebook. Also, they try to give you assistance for the information you ask. What it will help? It will help to the masses. It will, because you need not to have the direct intervention. You'll post something, everybody can read it, follow it, and they can get the information. So this is the beauty of internet self-help sites. The next one is There are two things in technology for access to justice. The first one is on my left hand side, application of technology, and on my right hand side is service provider. So quickly see that these two things working, differently. At times we mix them in the bigger umbrella that it is role of technology, but they both are two different things. The first one is application of technology in filing of an FIR online. Friends, in new criminal laws, it has been given in BNSS that you can file an online FIR. I'm not talking about zero FIR, I'm talking about the online FIR, which can be sent through email, through WhatsApp of the police station. Also, you can SMS to the official number of, this. That is application of technology. Earlier, only zero FIR was there in CRPC, but now filing an FIR online is also being given there. The second one is e-filing. As we have discussed that e-filing is an option available now to the people. You can check your status of case online. That is application of technology. You can also use online dispute resolution, that is ODR. And we all know that COVID has given at least one good thing after taking thousands of good things from us. COVID has given us an alternate to the court system, that is virtual court. After in COVID and after COVID, we have made challan courts as virtual court completely. We are now moving to making family court in second phase, virtual court. Then we will make in third phase all the quasi judicial bodies as virtual courts. So this is something which is coming, and it is an application of technology where virtual courts are saving so many things: time, money, energy, and it is helping environment also. If you need to go to court, you are driving 10 kilometers, your car, your cab, the bus is contributing to the environment. But you can say that, ma'am, the electricity which we are using in virtual courts, is it not costing to the environment? Friends, somewhere or the other, the balance will come. 1,000 into 1 or 100 is to 1. We have to at least take, as Bentham said rightly, maximum pleasure or minimum pain. Minimum pain will always be there. Minimum cost will always be there. We cannot done with the minimum cost. Minimum cost is the nature of nature, is a natural law. We have to follow it. What are the service providers? Service providers are robo advocates. We have heard so many. If I have advocates in my audience, so many advocates ask these questions to me, because I'm professor of law and technology, that, madam, will tomorrow robos will take my job? My answer is no. Robo lawyer can be there. Robo, lawyer can give an advice only, but can give arguments also. But when it comes to use human intellect, human, emotional intelligence, robo advocate cannot take an advocate's, position. So my answer is always no. Then using AI and legal research. This is one of the allegation which the nowadays we are seeing that one of the justice has been alleged that they have used chat GPT in his research. Use AI in legal research, but does not cut copy paste. When we ask our students not to do it, at least everybody shall not do it. That is one of the underlying principle. But use AI in legal research. Do smart work, but does not do a work which is not smart in action. Chatbots for legal assistance. Yes, there are so many, like, if you'll go to NHRC website, if you go to any other website, you'll see that chatbot is there to help you. Or if you'll go to Passport Seva Kendra, there is a chatbot for assistance. But will they be able to give a legal assistance? Yes, my friends, there are so many chatbots which are being developed nowadays, at least US, China, Germany, Australia, UK has Japan has done it. They have developed chatbots for legal assistance, but their assistance is systemic assistance. You'll ask question X, they'll give answer Y. If you'll ask question A and they don't have an answer for A, they won't be able to give, because as per their algorithm, they are only for the legal assistance. They can't replace the advice, or they may give advice. It may be possible they are not there for negotiation. The next one is service provided. The judgments are available online in regional language. There is an app which has been developed, Bhashini, which is for the judgments which are available online in regional language. This is one of the challenge in India. We have multiple, languages. English connects us all. However, there are people who may not be even able to read, speak, write English. So for them, their regional language is so important. So the Bhashini app is solving their problem. Then this dashboard DOG e-code project phase, what I was talking to you all, that virtual courts are now being developed. This is the link for that. And the last one in service provider is telelaw, which I'm going to discuss with you all in detail. This is the online hearing, which is new age access to justice, which we have seen in, COVID, post COVID, that there are online hearings, and this is a new normal. In this new normal, my friends, this is providing access to justice. That means you need not to go to, you means I'm talking about clients, I'm talking about witnesses, I'm talking about victims, because the complete new criminal laws are for their protection. If we are talking about, we need to protect the witness and victims, we have to give them a safe, sound environment where they're comfortable. So friends, when a person is comfortable virtually sitting and talking, that is an amazing idea. So online hearing is something which is solving the objectivity. Earlier, the camera trial was one of the dream. We used to take permission for camera trial in exceptional proceedings, but now camera trial or online hearings is a new normal. The next one is robo advocates, which I was discussing with you all, that the robots may be looking so bigger than an advocate in this picture, as you can see on my screen, but it's impossible, at least for next 20 years or maybe more, because we have recently seen that a robot has committed suicide. I'm sure that news you must have followed. If a robot can commit suicide, we are just reading the headlines. Nobody has gone to the depth and understand that the robots has not had that human intellect or emotional intellect and psychological intellect to commit a suicide. But there were other instances, other failures, other socket connections issues, where the robots was being declared dead. However, in India, where we have given a river a personality, a natural personality, it may be possible tomorrow, 30 years down the line, we may declare robots as an artificial person, and liability can be fixed on an advocate who is a robo for professional negligence. I am just hypothetically uh, talking to you. The next thing is online dispute resolution. This is present, this is not future, where it is rigorously, cautiously, and smoothly working for dispute resolutions. We have seen that ADR has been accepted by so many business houses, so many commercial transactions has been positively, beautifully been resolved by ADR. Now, online dispute resolution is a new mechanism where the disputes are being resolved, using the virtual mode. And it is, I need not to count the blessings by ODRs, but I'm telling you, this is a revolutionary idea where dispute, problems, situations can be resolved quickly, easily, and positively. With this, there are second exercise. You must be wondering why Madam is giving us all the exercises, because this is the feed to your brain where after getting the information, your brain shall stop and think that what are the Indian machineries who are using technologies as a means for justice. Please give just small, circle in your brain, think about it. What are the different machineries who are using technology as a means for justice, and write in the chat box. Uh, I don't know whether you have access to the chat box or not. Okay. So you can feel free and write in the chat box, or at least think, because this is important to think, because uh, I will provide the answers, but we shall know that where we are heading. The first one is, it was like, in the law colleges, in the law schools, I have seen that when the first time Supreme Court live streaming has happened, it was like a dream come true, sitting at Kanyakumari, looking at the proceedings in Delhi Supreme Court happening, when you need not to go to Supreme Court to follow the matter. Friends, it was a revolutionary idea. I think you all will agree, and I don't think so any other law school or any other advocate who has not followed that live stream for the first time. I myself was a witness to it, that yes, we shall give that kind of practical exposure to our kids, where they can see that how advocates argue, practice in the Supreme Court itself. The this is the projects which I was talking to you all. The first one is e-courts project, under the national e-governance plan. That is the first centralized idea, that let's make e-courts first. Second, it will facilitate the online case filing, e-hearings, and digital judgments. The next one is, it will provide access to all the judgments via e-courts portal. This is the link for the e-courts portal. We have seen live streaming of Supreme Court and High Courts have started, and it is improving transparency. What is happening in court. I remember when I was a young person and I have seen the parliamentary proceedings for the first time. It was to my amaze that this happens in parliament. After seeing the live streaming in courts, then that has also given me understanding, okay, this happened in court. Then AI in legal resource, Supas is one of the app which is helping judges with case research. I won't comment here that whether they're using ChatGPT or whether they're using any other any other legal AI, sorry, any other tool, AI tool in legal research or not. But Supas, that is Supreme Court portal for assistance in court efficiency, is one of the application which is there. Then fast track courts and virtual hearing. After COVID, the bail hearings on urgent cases, especially during COVID, we have seen, but now also it has been motivated that let's have video conferencing for bail hearings because there are immediate solutions which are required for immediate problems. Then we have seen NJDG, that is National Judicial Data Grid. It is a centralized database which are providing the real-time case information from district and high court. Friends, let's see this dream which is coming true, that we can also see what is happening in my district court, in my session court, and also in my high court and supreme court with my case. For that, you all have to have, a chain system. I have intimated to you, you shall intimate to 10 more people. Then it is also helping tracking the backlogs and judicial performance, because judicial performance is something which needs transparency, which needs accountability. So when we see that what is happening in this particular cases, we can see that how judges are performing. It is available for the public and legal professionals for transparency. Then ODR Samadhan is one of the application which is promoting ODR for commercial disputes, because we know that one day, dispute will arise handsomely, will cost me more than the cost of the complete dispute resolution. So ODRs are there so that quick, immediate, and positive, resolution will come to the dispute. Sama and Agami, there are also two private ODR platforms which are resolving small claims and corporate dispute online. Then RBI also has started, making a digital Lok Adalat, which is resolving the banking and financial disputes virtually. E-Lok Adalats, we all know that this has also been started, that let's have virtual Lok Adalats, because it may be possible that there are people in two different states and they're not able to come. So let's do it. Why? Because the conciliation will come, the solution will come quickly. It has been adopted by MP, Maharashtra, and Rajasthan positively. Delhi, Uttarakhand, and one more state, I think Gujarat is trying to adopt this mechanism of e-lok adalat for present, system. The next one is CCTNS. I'm sure you must have heard this particular thing when BNSS and BNS or BSA has come. That is Crime and Criminal Tracking Networks and System, that is CCTNS. It is one of the amazing platform which is digitizing the police records for better law enforcement. We can see that where the case is going, what kind of investigation, who's my IO in the case. So CCTNS is a revolutionary idea. Then interoperable criminal justice system is ICJS is also there, which linking police, courts, jail, and forensic labs for the seamless case tracking. You won't believe earlier these stakeholders were drift apart. Okay, police is doing its own work in their shallow. Courts are doing their own work in their own, zone, thinking that they are supreme. Jails are like, you bring it, the accused or convict. We are there only for the, reformation, so-called, and rehabilitation. Forensics labs are like, we don't have any responsibility. You give us evidences, we'll give you reports. Now ICJS has linked them together, that police will work with forensics lab, and both of them will be accountable to court, and court, forensic lab, and police will send a person to jail for reformation, and jail will report it to court and police, not only at the time of parole or probation, but also at multiple time of his punishment. This is kind of interoperable criminal justice system which is coming there. The next one is EFIR. We have discussed online police complaint. We have discussed. Delhi follows EFIR. For complaints. Then, friends, which I was discussing, that I will discuss this as last, is Ministry of Law and Justice has had few initiatives which are, good initiatives. The first initiative in the name is Tele Law Program. Telelaw program provides legal advice through common service centers, that is CSCS, okay, in the rural area. The problem was in the district there may be multiple villages. You just understand where I'm taking it to you. For example, there is a district, and in X district there are, let's say, 10 villages. Those 10 villages have a district court. Now, nearer to the district court, there is a district legal service center. To go to that district legal service center, cost is required, time is required, and also there is that sense that if I'll go and speak to some person, I need confidence. That is the most important. Courage is required because victims are already victimized and they may not have courage. So telelaw program has been initiated by department, Ministry of Law and Justice, through which a number has been given, and when the number has been given, also in the second round or first round, you can have a video conferencing which is connecting the citizen with the legal expert. That means you need not to go to district legal service center prima facie. You can be at your home, and with telelaw program, you can connect with video conferencing with a legal expert. Telelaw program brings legal experts, citizens, and also the middleman is there to connect them. See the beauty of this, everybody has phone, chahe was, irrespective of the smartphone, irrespective of a normal phone. If there is normal phone available, telelaw program connects with call also. If it is a smartphone, you can have a video conferencing. And for below poverty line plus women, this is free. Otherwise, for above poverty line, it takes 50 rupees for the registration. Now, the registration will work for lifetime. See the idea behind it is you can connect it from anywhere. The legal expert is sitting in MP. The person who needs advice is in, let's say, UP. And through video conferencing, they both are connecting on telelaw program. And the program is, uh, you know, we we have some questions like, what about the confidence? I am telling my problems to the second person. Will there be confidentiality? Will there be right advice? Will there be accountability? Will there be the proper legal assistance and hand holding? The answer is yes. So this particular program has changed so many people. If you have yet not seen this, please go to the website of ministry today and see the telelaw program. They are doing a good job. The next one is pro bono legal services. This is Nyay Bandhu scheme. It is based on an app. You can download a mobile app to connect with the marginalized people with volunteer lawyers for free legal aid. With free legal aid does not mean that poor legal aid. Free legal aid means it is my commitment being an advocate that I will do the social service because I have been asked by the Advocates Act, under which I am registered, that I supposed to do or pay back to my society, who is, towards it, I am responsible. So this Nyay Bandhu app is also connecting marginalized people with the volunteer lawyers. You may say that, madam, even district legal service authority is doing the same. Yes, they are doing in a four wall. This is a mobile app I'm talking about. So the advocate is also available on app, and the person, the needy is also available on the app, and they can do it. Actually, the third one is LIMS, that is legal information management and briefing system. It is digitizing the legal case records for better governance and tracking. It is also there because to track that where is my case, how it is, working, how much is it affecting, effective, and am I in the safe hand? So this is the app which is helping and working. This is, I was talking to you all that this is the Nyay Bandhu, this thing. This is what they are doing. They, with the pro bono legal services, they have created an ecosystem with leveraging technology. They have created a pro bono panels of high courts. They have also connected pro bono club scheme law schools, and they have also connected the CSOs, startups, law firms, legal service authorities with, an app. The app is helping everybody. So everybody has, it's like a complete circle. Everybody has, connected with an application and helping the needy person. You can be a law school, you can help. You are an advocate, you can help. You are an NGO, you are a startup, you can help. So through technology, you can help. But you just need a sense of, helping nature. If you don't have, nobody can force you. If you have, you can help it from the corner of any, from the point of anywhere, from the corner of any place through this particular app. This is the Nyay Bandhu scheme. I've taken this from them. You can see that through an application, they have connected the people through the High Court panel. They also, the law colleges, they are making pro bono associates, and pro bono associates are also helping the beneficiary. So their aim and outreach is this only, that we have to help the needy one. The motto is simple. They want to assist the person who needs it the most. Now the next one is French Cyber Appellate Tribunal and Digital Consumer Courts. We have seen that cyber appellate tribunals are also there who are handling the cyber crime related disputes. There is, the cyber crimes, they are completely online. You file an online complaint, either you call them and your case is there. The second portal is e-dakhil. If I don't know you are aware about it or not, you can file a consumer complaint against unfair practices digitally through e-dakhil. So these two are again a revolutionary idea. The next one is AI and blockchain in justice. So VAS is one of the tool which is AI based translation tool. Helps translate the legal documents into legal, into the regional languages. Blockchain in land records, again revolutionary idea, used in states like Telangana to prevent land disputes and fraud. Now there is like DigiLocker, you all must be knowing. There is a land record locker where digitally you can save your documents and nobody can convert, because it is so easy in India to convert a properties document. So land records is there. You are saving it in a locker, kind of thing. The key for the locker only you know. Not even your advocates is required in it. So many states, Telangana has done it, Gujarat has done it. I know Jharkhand has done it, UP is doing, Maharashtra is doing. So this is something which is very, very, relevant. It is coming where you can save your property and nobody can touch it. Now, question comes, ma'am, what are the adverse effects? You have told us so many positive things. Now, let us discuss some of the challenges, because nothing is perfect in the world. The first one is availability of internet access in low income communities, or the societies where internet is not available. That is for, no, problem number one. Whatever I've discussed with you, we need technology. But what if the technology is yet not reached to the place? Question number one. Question number two is, what if there is very low income people who cannot afford technology? But very minimal number of people are there, but yes, there are people. So that is problem number one. Problem number two is web content and interfaces do not conform to those with limited literacy and language skills. Whatever I've discussed with you, mostly largely in Hindi or English. Largely in English. Now, what about the regional language? Can Google translate everything? And can the translation be exactly the exact version of the information provided? We know that, first of all, it's a legal language. Second, it's in English. Thirdly, if we are converting it, will it be the proper translation? Then it is a challenge. The next one is lack of convenient access to internet location, which I've combined in the first one. Lack of outreach and personal assistance. Lack of awareness completely is missing. Friends, there are programs, there are advertisements, there are, there are channels which have been developed to make people aware, but we need to have more outreach. How to do it? Again, for making this outreach we use internet, but if the person does not have access to this information, how to assist them? That is another challenge, which is yet a challenge. The next one is infringe fundamental right of access to justice. uh, Technology is not there, internet is not there, mobile phone is not there, electricity is not there, rightful information is not there. Don't you think that it is infringing my fundamental right of access to justice? It is. So we have to solve them one by one. And to solve them, there are ways to eliminate. The first one is evaluation. First of all, we have to evaluate that how to give the judicial access. Then, second, we may have to make client community awareness of available legal resources. Third, we have to examine the reasons for non-usage. We have to see that we have given food, the person is hungry. Why the person is not eating? There may be reasons. It's a non-veg food, the person is vegetarian. Maybe reason number one. Reason number two is the person is hungry, but the person does not know that how to eat it. Maybe possible. You have not given proper means. That means spoon or fork. It may be possible. Third, trust is not there. The person is hungry, but the food which you have served, trust is not there. So we have to examine that information is there, tools, application, everything is there. Still, people are not using it. Why people are not using it? We have to conduct surveys. We have to conduct thorough research. Then when we have given everything, why people are not using it? So client community awareness of legal resources and then examination of non-usage is required. Then strategic relationship. Pool the resources. We every time we say that we don't have enough resources, then pool the resources. First is strategic relationship. Second is share in computer lab expenses and in the labor or in the manpower. The third one is bookmark the legal websites on computers. Make some electronic systems or kiosks, which I was talking to you all, and bookmark the websites or bookmark the applications on the kiosk that these are you can access. And also could be audio video there. Okay, audio is available. Maybe you can play a video how to use it. So that is something which is strategic relationship. Refocus on financial resources is the third way how we can eliminate this situation. TOP, that is technology opportunity program, we have to have. And TIG, that is technology initiative grants. Program shall be there and grant has to be there so that the program can reach to the maximum people. This is my way forward. My way forward says, and we have to read it. Imagine what will happen if everyone is included. Imagine what will happen if everyone has access to justice. Imagine what will happen if the equality of justice gets better and better. So, these three imaginations, just imagine today. Just imagine that you will be included everywhere. Don't you think so that it will make you happy? The kind of all mental stress, trauma, mental health, mental agony we are talking about, your inclusivity will take everything away. Second, imagination. Imagine if everyone has access to justice, transparency, accountability is in the society, and we all knows that whatever is happening, I have access to justice. And lastly, imagine if the quality of justice will be better and better. Will it not make a happy, society? I think it will make. With these words, I wish to, open this platform for question and answers. With thanks to all organizers for having me here. Thank you, sir. Over to you for the questions.
Participants can unmute themselves and ask the questions. Ma'am, we have a question from boardroom.
Please.
So, ma'am, what about the privacy and data security concerns when it comes to tech-based ADR mechanisms?
Thank you for this question. When I am talking about, applications and the situations where we are, giving informations to, secure system. I am not giving the informations to any XYZ or private party. I am giving access to my information to government driven applications or projects or places. Please understand it, where security is paramount. We are talking about access to justice. We have to see that the government is responsible for data privacy first. However, there could be instances where data breach or data privacy there could be instances. In the cases in the access to justice, we are not providing any personal information. However, you all, I can see from the boardroom, you all are having smartphones. You must have at least 10 applications. And you all have yourself given access to all of your information to those applications. So we are not living in a world where data is safe at all. Thank you.
Thank you, ma'am. There's another question from the boardroom.
Please.
My name is Raksha and I'm from 3 years LLB final SEM. My question is, if the access of technology is too much and the people are using, as the first question was about the privacy, wouldn't it also be a threat? Like people can use it for threatening people by digital arrest or issuing fake summons.
Okay. Raksha, thank you so much for this question. The topic is role of technology in access to justice, not access to technology. We have to understand there are two things: role of technology in access to justice. In access to justice, how we can use technology. Yes, you are absolutely right when you are saying that there could be situation for digital arrest. There could be situations where the person is threatening others. For that, we have protection. First thing. Second thing, whenever we are using any kind of government application, for example, telelaw. only three parties have access to information: telelaw, victim or complainant, or person who is filing that particular or talking or registering that thing, and the lawyer and the advocate to whom he is having video conferencing. We have to understand that when we are filing for three of the things, there is again a standard form of agreement where telelaw and advocate is under the obligation through the contract that they cannot share the information with third party, first of all. Second, if they are sharing, likewise we are having the documents in public availability. Like if I'm filing a case of mine in court of law, everything is in public access, in public domain, but they are not accessible to public. We have to understand there are two terminology. They are in public domain, but they're not accessible to public. Even if you need to see a file, you have to apply and the judge has to give permission. So likewise, if you need to have anybody's data or information, hackers can do anything. I am not denying. Hackers can do anything. But the public platform and entities who are taking the responsibility for access to justice, they won't be doing wrong. Thank you.
Ma'am, there's one more question.
Please,
So,
please.
what is the approach that we should be taking when it comes to liability on intermediaries when it comes to use of technology for access to justice?
Thank you so much, dear, for your question. In 2021, we have we have guidelines for intermediaries, but those guidelines were not for the intermediaries like self-help law sites. Those intermediaries were like public platforms, like maybe OTTs, maybe social media. So when intermediaries are having somebody's data and misusing it, those were applicable to them. But when we are talking about the applications where I am creating my account, for example, I've created my account on SUVAS, the Supreme Court application. And I cannot create my account like I don't have a case and I can create an account. The answer is no. When I'm creating an account, I need a digital number of my case. Then only I can create. When I'm creating it, I'm giving few of my basic details. Those details are saved in the server of SUVAS, which is only accessible by the authorized person, except hackers. Nowhere I have denied that it is not threat to social security. It can be, but the system is so protected that there will be no data breach. There will be no, that is assured. Otherwise, we will not be making everything public like this. The application itself are so strict and protected in nature that it is secured. Yes, please. Thank you.
Thank you, ma'am. Participants, are there any more questions? If there are no questions, with your permission and with the permission of Dr. Kalpesh, can we move to the vote of thanks and conclude the session?
Any other question? Last question. We have a couple of minutes, maybe. Last thought or remarks, anything? Okay, I think there are no
Before,
questions.
if I may
Yeah.
take 2 minutes, sir. Before anybody is asking a question, let me just make, because three of the questions which have come from the boardroom were revolving, nearer to data privacy and breach of, data. Dear friends, we have to understand that when we are talking about access to justice, it is more of the government side or more of the application side, the information which we are receiving. It's like making transparency. So when we are making transparent something, There is no threat. For instance, question of defamation may come. For instance, we are making something public, and where the name of the convict is given, and you are from the convict side, you are filing a case that how can you publish a convict's name? We have in court of law that convict's name can be published except in few of the cases. So the understanding which we are doing, or which we are thinking that it may be a breach of privacy, it won't, because it is more of one and one. Okay, I am having my login ID credentials, and in my login ID credential, the information which I should see or available to me is available. So it's like your mail ID, you have the login ID and password, you opened it, you can see your emails. It's like the same. So these were my final remarks over the questions. Thank you so much, everyone.
Thank you, ma'am, for your insights. I would now request Afreen to render the vote of thanks.
I, Afrin Taj N, student of JSS Law College, presently studying in second semester BBA LLB, deemed it a great and profound privilege to propose vote of thanks on the 10-day online course program on ADR, Legal Aid and Allied Laws, jointly organized by JSS Law College Autonomous Mysore and Pro Bono India. First of all, I deeply extend my thanks to the 6-day session speaker, Dr. Navtika Singh Nautiyal, for her enlightenment through the session. Thank you, ma'am, for encouraging us throughout the session. Thank you, ma'am. Next, I would place my gratitude to founder of Pro Bono, Dr. Kalpesh Kumar L. Gupta, and Chief Executive Professor K.S. Suresh, Principal Dr. N. Vanishri, and Faculty Coordinator Asma ma'am. I would be failing in my duty if I do not happily acknowledge the presence of 100+ participants and coordinators for their support. Tomorrow we have online test and session will be resumed from Monday. Till then, stay tuned. Thank you, one and all.
Thank you so much, dear, for
Thank
the
you very
wonderful.
much.
Thank you so much. I would like to thank Kalpesh, sir. Thank you for inviting me, having me, Professor from JSS College, and all the dear participants for their patience hearing. I hope I was able to create a difference in your understanding. Thank you so very much. Thank you, everyone.
Thank you.